Good afternoon, everyone. Thank you very much for joining us. This is Startup Legal Q&A number 11. We've been doing these for 11 months, although we've been doing our Startup Q&As for almost 5 years now, just over 4.5 years. And we've had about 290,000 people that have tuned in, whilst we've answered about 3,000 questions. The people that have done that are about 300 of the best people in our startup ecosystem, from founders to operators to the lawyers like today, investors, CFOs/accountants, and all that jazz. So we're here today because unfortunately over 90% of startups fail. And the top 3 reasons for that are often mentioned being 1, market fit, 2, running out of money, and 3, not having the right people, which they are true. And most things, if something goes wrong in your business, you end up going downhill and lose your business. But if something goes wrong with your legal side of your business, you may also end up in prison. Now, I know I'm kind of being a bit OTT here, but unfortunately, including yours truly, we startup people aren't that great when it comes to ensuring that we're always on the right sides of the law, not because we are rogue, but because it's hard for people to fully understand these. And sometimes, the smallest things can kind of blow out of proportion. But fear not, because today we have 4 amazing people with us who are going to pretty much answer whatever questions we may have in terms of any legal uncertainty or challenge that you may be going through right now. They're going to be here with us for the next 57 minutes. And if you have any questions related to the legal side of your startup, please do not fear. Please do not feel shy. There are no wrong questions. Your questions can be on anything from your incorporation, founder agreement, shareholder rights, IP protection, term sheets, compliance, regulatory requirements, non-disclosure agreements, employment laws, legal documents, and various other templates and contracts. Perhaps you've got some disputes, whether it's with your co-founders, investors, board, or even that early stage employee/advisor. This is the place to be, and these are the people to ask. The way this is going to work out is quite straightforward. We'll start with some introductions, then we'll go on to some do's and don'ts from the panelists, and then we'll start answering questions. Now, for those of you that are on the live streams, whether you're on LinkedIn, YouTube, Facebook, or Instagram, please be aware that unfortunately we are unable to monitor your questions there. Therefore, if you do want to ask us anything, you'll have to join us here on Microsoft Teams. It's audio only, which means you can tune in from anywhere via any platform or device. And it doesn't matter if you're working from a shared office in London, or walking your dog in Surrey, or perhaps making lunch in Liverpool, or having lunch in Glasgow, or changing baby nappies in Bristol. You can tune in from anywhere. All you have to do is either click on the links on those live streams or simply go onto our website, startuptoscaleup.club. Again, the website, it's startuptoscaleup.club. You scroll down a little bit, you'll find today's session, that is Startup Legal Q&A number 11. Click join. It's a quick registration on Luma. That will get you on to the Luma site there, where you'll be able to see the links, or the link rather, that gets you here onto our audio call. Once you're here, simply drop your question in the chat. We'll give you the mic, introduce yourself, and then fire away with your questions. Now, without further ado, let's go on to some introductions. My name's Anton Cole. I'm an Albanian in London working with startups normally right after they get investment. I embed within their teams and help them hire and keep the right people. I also do some growth advisory work with a few other startups and some accelerators, help some angels and family offices with their due diligence and assessment. We'll start with the ladies of the house, Sharon, Ishita, and Andrew, and last but not least, Saman. Please take it away, team.
Hi, I'm Sharon, Zachariah. I work with a lot of startups and scale-ups, and as well as medium-sized businesses who are quite established on their commercial contracts negotiations, setting up their documents and processes that comply with their contracts so that they get a really solid start in business. I was an in-house lawyer for about 11 years, private practice lawyer heading departments in London for 4 years, And now I have my own business called Innovation Law.
Hi, Anton, my fellow esteemed panelists, and everyone listening. Happy New Year to all. I'm Ishita Luthra, founder and lawyer at Lex One Consulting. We help startups and businesses with their legal needs, from setting up to preparing constitution documents, business contracts, brand registrations, website T's and C's, investment documents, and loan arrangements, etc. I've also written a book called The Inner Circuit, which is a book that explores how mindfulness in yoga and breath work can help us deal with the complexities of modern life. Again, happy to be here and answer your questions today. Thank you.
Hi there, everyone. My name's Andrew Pannell. I'm a partner at Haynes Boone, which is a UK-US international law firm, Dallas, Texas, headquartered. I'm based in London and do a lot of work on the venture capital and private equity side of things, principally on the downstream transactional side, acting both for fund managers as they deploy the capital and also with emerging companies. We do quite a bit of work both in UK, Europe, and also across the pond in the US, and also look at UK, European businesses as they're looking to expand into the US and advising around that.
Hi all, I'm Saman. I advise high growth tech startups predominantly, and plug in and as a fractional general counsel, so advise across all aspects of their business as they grow. My background is I've worked in some of the fastest growing tech companies globally, probably as they expand internationally, from Go Cardless to Checkout.com, to name a couple. And now I use sort of that experience and expertise to advise smaller companies on their way with the kind of key advice they need in scaling and sort of juggling legal issues and risks as they come in. So it's great to be here, and hopefully we can all help answer some of your questions.
That is an absolute dream team. Thank you very much to all four of you panelists. I hope we can have a do and a don't in terms of what is important to you when it comes to early stage legalities.
So do get the right structure for your business, whether it's a sole trader, partnership, or a private limited company. Having the right structure combined with the correct understanding about the tax exposures of your business will help you give a good start. So as a sole trader, you don't need any foundational documents, but if you are a partnership, you'll need a partnership agreement, or if you're a limited company, then you'll need to have your memorandum and articles of association. Most founders adopt the model articles because they're easy, but sometimes model articles are not fit for purpose, especially if you are a sole director and founder. So get the right documents once you finalize your structure. The don't would be to don't ignore your company's house filings if you've made any changes to your company, because any failure to file the necessary filings can attract penalties. And especially if you're preparing to get investor ready, you need to have your compliances in order, as they don't sit well with investors, especially at the due diligence stage. So don't ignore your company's house filings. Thank you.
Thanks, Ishita. Okay, in terms of a do, if you're at the outset of your journey and you have one or more co-founder, one of the things to at least consider up front is what that relationship looks like, by which I mean, in the worst case, what happens if it breaks down. So something that often will go into early stage documents, whether that's in the investment document or in a founder agreement, is some kind of clawback mechanism in case one of say two founders were to leave the business. It's not really not a popular topic necessarily, or a positive topic to talk about, but in that worst case where someone does decide to move on, the last thing you want is for that exited founder to retain a significant portion of equity. Otherwise, the cap table will not look great when it comes to future hires and or external investment. So something to at least consider up front. In terms of don'ts, I guess it's always challenging early stage, but I wouldn't go too cheap. Appreciate that there's a limit to budgets that you can expend on advisors early on, but just be careful about getting some of the key things right. So a little bit like what Ishita mentioned around making sure you've got a good solid structure in place. But for example, where you're looking to set up an ESOP employee share option plan, or you're looking to structure your investment to take advantage of things like CIS or EIS, UK tax treatment, there are certain really important, quite basic often, but quite important things not to get wrong there, which may come back to bite you in the future. So some of those basic elements are really important to make sure you don't get wrong up front.
On the do side, and I think in a way following on from both what Andrew and Ishita said is, in terms of foundational things, do make sure you own the intellectual property that you're building. So for example, if that's a tech company building software and you're using outsourced providers, make sure you have agreements in place where the IP is assigned to invest in the company you're building. If you're a founder and have been working on something before you set up a company, make sure you transfer the IP into the company. That's especially important once you get to future funding rounds. The reason behind making sure you own the IP is that that's where your value is, and that's where the brand and the value in the IP will develop over time, and that's what becomes a saleable asset in the future. So worth thinking about and getting right up front, as opposed to sort of firefighting and trying to fix down the line. And then my don't would be probably maybe a bit rare for a lawyer to say, but don't be paralyzed by legal issues throughout. A startup journey does involve risk. It does involve moving forward and growing. So the key is not necessarily to get everything 100% right up front, but it's focus on the big things. I think it's understand key risks and mitigate them where possible. So I think it's just getting the right advice, like Andrew said, as opposed to being paralyzed by the potential for failure.
Right. So you're going to be working with a lot of suppliers and other sorts of counterparties, and you'll want to do your due diligence on them. There is a temptation to jump in and find someone who's made an offer of something, but you'll need to meet a few people and make sure you pick the right ones, ideally in your own jurisdiction if you can, so that if there's anything that goes wrong later, it's not a headache to try and get hold of these people. So do your due diligence and pick your counterparties quite carefully, because they're going to contribute quite materially to your success or failure. My key don't is, please don't decide that you don't need a contract. That is an error, because at the time when we're involved in our own business negotiations, we very quickly think, what could go wrong? We very quickly think we've established all the ground rules. Now, the reason why contracts are a bit longer than just a few text messages is because in the past, so many different things have gone wrong. And while we don't want to cover every eventuality, we do want to cover the most important key themes that have kept going wrong over the years, and that we as lawyers are able to help you manage as risks. And if you do both those things, which is pick your suppliers carefully and don't ignore the contracting side, then that should set you up in a much more solid way.
Amazing stuff. Just a quick reminder, this is Startup Legal Q&A number 11. We're here to help UK startups with whatever questions you may have in terms of your legalities. There are no wrong questions. There's no need to be shy. It's a learning curve for us all. You can ask us today on anything, let's say incorporation, founder agreement, shareholder rights, IP protection, term sheets, compliance, regulatory requirements, non-disclosure agreements, employment laws, legal documents, and various other templates and contracts. And perhaps you want to talk about disputes you may currently have from co-founders to investors, boards, early stage employees, suppliers. Without further ado, first question. This is from a NedTech startup in Grimsby, Lincolnshire. Grimsby, Lincolnshire. The problem they're currently going through is that a corporate venture capital firm keeps changing the terms after initial commitment. So she then says, our EdTech startup in Grimsby, Lincolnshire had a term sheet in place with a corporate venture capital firm that promised funding. However, after stringing us along for several months, they have now proposed different terms that are less favorable to us. Can we refuse these new terms and claim breach of contract? Or are we bound by the original deal despite that change in approach?
Yeah, I'm assuming this term sheet was signed at least at a minimum and set out those key terms. As you may be aware typically term sheets don't tend to be legally binding documents, so they're more just statements of intent, subject to certain key provisions around things like cost, confidentiality, exclusivity. So my gut instinct, I'm afraid, is that given the non-binding nature of those terms, and they'll be subject to things like due diligence, etc., and negotiation of definitive documents, it's going to be difficult to try and enforce on those terms, notwithstanding the fact that the relevant venture capital firm appears to have changed the goalposts a little. My immediate reaction to that, you can still try and go back to them from a good faith commercial perspective and be reasonably robust around understanding the rationale for why they're changing those terms. And of course, from a commercial perspective, if you have other funders potentially available, you can also use that as leverage in order to bring them back into line. The only other thing just to keep in mind is, to the extent that the term sheet contains any binding terms around things like costs or breakup costs, just to be aware of those and make sure that if this investment does terminate, that they don't try and push any of their costs onto you as a business.
Andrew's covered it well. There's two things I would add, which aren't necessarily legal things. As Andrew said, in good faith, things in a term sheet are kind of followed through. So it might be worth drilling into why they're changing the terms. They may feel that something that you've disclosed subsequently has changed, moved the goalpost or something like that. So it's good to understand that. Then a second thing to think about is, obviously, even if there's no legal claim, like you tried to force them into funding or something like that, you've got a long-term relationship with these investors, and ultimately they've got an interest in your business and doing well. So if there's misalignment from the start, you might see this as a lucky escape from something that might have actually been quite a painful relationship longer term. So yeah, if there are alternatives to find investment, that might be a good approach anyway.
Keeping in mind what Andrew already said about breakup costs, you are therefore also free to consider other avenues. So while it would be extremely beneficial to also follow Saman's advice and find out what it was that made them change their offer, with that further information, you're probably in a better position to also consider other prospective investors now. So having your own freedom, you might think that this might not be the best partner for you because of this changing of the goalposts. And that's the vibe I'm getting. Also, while it's nice to have, an offer on the table, the fact that you have an offer probably means that you could get another. So important to consider your options and whether, they've shown their true colors, or whether there's something that you might need to work on that they've identified. A bit like painting a room in your house before putting it on the market. You might wish to just address that issue so that you can perhaps get a better deal.
The only point I'll touch upon is where you've asked, can we refuse these terms and claim breach of contract? To which I'll say that, you can potentially look for other investors. The way I would approach it is I would at least have a chat with them to understand what went wrong and why there has been a change in the terms, or why they're offering different terms, as Saman has suggested. I wouldn't suggest suing them or going down the litigation route, because that will entail costs. Again, you're a startup, you want to devote your time and energy into growing your business and scaling it rather than getting into a litigation loop. My suggestion, get an understanding of what went wrong and move on from there. My advice would be, don't go down the litigation route.
Thank you very much to all four of you. Really appreciate that. I want to go to another question. So this is a design and build software development startup based in Wakefield, West Yorkshire. Wow, this is quite a question. As a co-founder of a software development startup, I'm considering selling a portion of my shares to a private investor due to significant personal financial pressures. My fellow co-founders have expressed strong objections, citing concerns over the potential dilution of control and the impact on decision-making within the company. I need to understand the legal mechanisms available to them that may allow them to block my sale, especially in light of our shareholder agreement. Specifically, do they have any veto power over the transfer of shares, or are there specific clauses that grant them the right of first refusal or tag-along rights? Additionally, how can we mitigate the potential fallout from the situation to preserve our working relationship and the company's long-term goals? Assumption is the mother of all wrongdoings, but I'm assuming here, since you've mentioned these things, and I'm hoping you've read the contract if you had any, that you didn't instigate or you didn't specify any of these things that you've mentioned in terms of veto power, tag along, and first refusal. That's only an assumption. But it would have been nice if you were here so that we could double check. If you don't mind, panel, let's just go with assumption that those provisions are not in the contract. Hence why this co-founder is asking these questions. By the way, if you don't feel you've got something to add, it's totally fine to just move on to the next one.
Maybe others have more of a view on this, but I would say normally there are restrictions around share transfers in the investor agreement or potentially even in the articles, depending what the articles say. So yeah, it's known that private shares or shares in private companies are relatively illiquid. So it's likely they do have some control, especially, again, depending on where the majority ownership sits. If you own the majority of the shares, maybe you have more control. Key question is, what's in the documents to be, I would say you can't be definitive about it, but it's worth checking the documents, getting some legal advice on the documents to look at what can or can't be done. Take it a step back. Obviously, if you're facing deep financial pressures and you get on well with your co-founders, maybe there's a way of trying to release some capital for you to resolve some of those issues if you do want to continue the long-term relationship. But yeah, otherwise I'll hand over to the others to add their thoughts.
Saman has definitely summed up some of the key points. Without looking at the contract, it's hard to say what your particular circumstance is. So let's go to the relationship side of it and say, what can you do if you were to want to go ahead and if the contract allowed it? Perhaps you could consider their meeting the potential investor and being comfortable, because they might need to make sure that investor doesn't have the same rights that you as a co-founder have. While they might potentially come around to the idea of an outside investor, the question really would be, what say would that outside investor have in your business? So that is possibly a very important factor, rather than, well, somebody just takes your place. They're not going to do what you do, will they? So I think it is a complex handling of what it is you're giving away that will really matter. And on the relationship side, going back to Saman's suggestion, which was to consider whether there may be an alternative way of easing your financial pressures, because you're also diluting your own stake in the business, are you not? And is that perhaps not desirable in the long term? It's also something to consider.
My view here is that you're asking whether all these rights would apply. So I'm guessing there is no shareholders agreement or co-founder agreement in place, because if it were, you would be aware of these rights. So first point is, in the absence of any agreement, check your articles of association. The board can have the ability to refuse a transfer if it doesn't seem the transferee fit for the company. So there could be something in your articles if the company has adopted amended articles, or even sometimes in model articles, you can see that language. So do check your articles of association. The other point would be, whilst you want to transfer your shares in order to get a financial incentive to support you financially, you could consider entering into an employment role with a company where you get paid a fixed salary. You can change, your ownership structure, in the sense, if you want to, Sharon has mentioned, you can have different rights. So right now, I'm not sure how much stake you own in the company. So if you have a considerable percentage, then it may be worth restructuring, in the sense, maybe transfer a portion of your shares to the investor, or offer them different rights, a different class of shares, and hold an employment or, a contractor relationship with a company where you get paid fixed salary for your services, because you're a co-founder. So I'm guessing you have a specific role in the company. So yeah, these things you should consider and speak to your co-founders as well as the investors And I'm sure you can arrive at a solution. You don't necessarily have to fall out. So in the interest of maintaining a working relationship as well as preserving some of your equity, maybe you don't have to do all of your stake and control. So think through this carefully.
I guess the first takeaway is, as mentioned, really important to have a look at the actual documents. So there'll be the articles of association, whatever form they take, which may or may not contain restrictions. And then you do reference a shareholders agreement potentially. So maybe then what is a shareholders agreement in place? That is your starting point. And just in terms of the basic restrictions that may apply, there may be a right of first refusal on any transfers of shares. So that's the first point to check. And whether or not there are any exceptions to that right of first refusal, for example, a permitted transfer. And sometimes, as an example, you can deem a permitted transfer by way of maybe a board approval plus an investor majority consent, depends on the construct of the contract. That's one thing to consider, whether or not you're actually banned by that ROFA. There's also a concept of co-sale, which is a restriction often placed on founders in the context of a venture-backed business, whereby if a founder is looking to sell a portion of their equity, then again, unless it's a permitted transfer, it would allow investors to also sell down a portion of their equity. So that's another restriction that sometimes applies. And then the final main restriction, just to check, is there any overarching absolute lockup on transfers of shares by founders, which is sometimes placed either, again, by say, a lead investor in an externally funded business, or potentially into founder because your fellow co-founders want to have some control for this type of situation. So those are the three key areas to consider in the contracts, and happy to take a look separately if you wish. Just thoughts in terms of the overall process quickly. Whilst they may be a little concerned, your fellow co-founders, around dilution, etc., that's sort of understood. That being said, like any good startup, which is often cash-strapped and bootstrapped, it's quite normal for founders to be thinking about liquidity, or at least partial liquidity. So it's a perfectly fair thing to be considering. Hopefully, having a sensible conversation with them, or following on from that, you can try and get somewhere. And the points around the investor profile, I think, are very on point as well, that Sharon and Saman mentioned as well. The other thing you could consider, if they're genuinely concerned and those co-founders have the financial power themselves, is whether you could sell back to those co-founders. That might be another route, at least, to consider.
Thank you very much to all four of you. Appreciate that. We are now going to go into question 3. So this is a cybersecurity startup in Haverhill in Suffolk. Okay, long lost associate threatens lawsuit. Okay, that's an interesting one. That happens way more often than we'd like. In all the years that I've been in and around the startup ecosystem, most founders tend to worry about stuff going wrong with investors. But guess what? It's mostly with co-founders and other people. Question. So, long lost associate claims the idea for the cybersecurity product was theirs. Question. Our cybersecurity startup in Suffolk has been developing a new threat detection system, and a long lost associate whom we haven't heard from in years, is now claiming that the idea is theirs and threatening to sue. The product concept has evolved significantly since our initial discussions. We have documentation and emails proving our ownership. What legal protections do we have to defend our position, and what steps should we take to resolve this potential claim without escalating into a lawsuit? Now, he says associate, so I'm not sure whether to assume they were somehow involved in this business at all, or maybe it was just conversations, I don't know, like working for some other company together. And so it sounds a bit wishy-washy, but let's hear it from the legal experts.
So on the plus side, an idea in itself can't be protected. So it's very much about what exactly their involvement was. Because anyone can copy an idea. I can go out and do things that have been done before, but I'd have to do it in my way. I can't copy the code because that would be a breach of copyright. So if you're brainstorming or chatting over a drink and someone says, wouldn't it be great to have an online bookstore? And then later somebody starts Amazon. Well, you can start another online bookstore. That's no problem. So really, it's down to what their contribution actually was. And if they actually had a material contribution that you and would like to acknowledge, then perhaps you can offer them something in exchange for their actual contribution. And if you feel they didn't have much of a contribution at all, and, that contribution in a commercial way, it could simply have been an idea. And you might think, yeah, actually, we'd like to recognize that. If they own any of the intellectual property in actual fact, then you probably might like to make some kind of offer. But if it's nothing like that, then it's not perhaps in danger of escalating into a lawsuit. The best way to usually prevent a lawsuit is to have a conversation that may only work if the other side is being reasonable in the first place. So preventing a lawsuit is as easy as the person on the other side of the table wants it to be.
To reiterate that an idea or a concept is not itself an intellectual property, right? So where you've mentioned is a long lost associates, I'm wondering what their capacity was and what capacity were they engaged with you at that time, whether it was under a contractor arrangement or an employment arrangement, or whether there was an NDA in place, because generally these documents have clauses about assignment of any intellectual property. So do check what documents you had in place, because you say that you have documentation and emails proving your ownership. So if you can establish that they have, in essence, assigned their IP whilst they were engaged with you, then you can establish your ownership in that manner. And if negotiations don't work, then at least you have your legal position right, where you can demonstrate that the IP was assigned, or a non-disclosure or an assignment deed was in place, which will strengthen your position legally. So if at all they were to pursue a legal action, you will have a good actionable defense as well.
Just two things I would add is, one, just reading off the face of the question itself, seems to me like this is a bit of a try-on because it's long lost some time ago. And yeah, it's fair to consider in what capacity. But I would have thought that if a discussion is not, because it doesn't sound like they are being particularly sensible in terms of their approach. If you need to firmly worded email or letter back refuting any alleged claims on their part, you may well just do the trick, because I doubt if they're an individual, they're going to want to start expending significant cost and time trying to actually bring a claim. So it feels a bit of a triumph as far as I'm concerned. Of course, if you do write any communications, it should always be done in a professional and calm, measured manner. That's probably the most practical way of trying to knock it on its head, and then hopefully leave it at that. And the only other point I would just keep in mind, to the extent there is any genuine risk or legs in that claim, is just to consider exactly what you do have in terms of, and depending on the nature of the IP that you've developed, whether or not there are any steps that you can take in order to protect that IP from a legal perspective, whether it's registration, etc., or otherwise.
Yeah, I think it's all been well covered. So I think a key question is, were they an employee or a contractor? And what do those terms within any agreements they signed say? If they were in the absence of an agreement, the presumption, I think, in the case of an employee is any IP developed during the course of that employment would vest with the company, whereas with a contractor, the rebuttable presumption is that it wouldn't, and it would vest with the contractor. So it's worth checking those contracts and making sure there were express terms in there that assigned any IP to the company. The other thing is, there may not even be any IP in place here if it was just an idea, as people have already covered. So think about what IP there was at the point the employee or the associate was in place, and then also think about what you've developed since then, because all the stuff that you've developed separately from them is your IP. So I don't think they have a claim on that. So I think that's the key stuff. As Andrew said, I think this is a bit of a spurious claim from the sound of what we've heard, but it is on them to make the claim. So you could almost see if they come back with anything, get your ducks in a row, make sure you understand your position and that it's really strong, but let them see if they're going to make a claim. As Andrew said, you could drop a letter just rebutting all of their arguments if they put anything coherent on paper. And then the final point of view, if it was many years ago, there is a statute of limitations, which is 6 years to make claims. So it may be that that period has passed, depending on how long ago that they were with you. So I think there's lots of reasons to be encouraged, obviously, without seeing all the facts. And yeah, always happy to have a more detailed conversation with a bit more information if you do want to send one of those letters or something like that. But yeah, ultimately, on them to claim, and really, I don't have massive concerns on this one without more information. The devil is in the detail on these things. But if you have put in place an employment contract or a contract or consultancy agreement that expressly protects your IP in the right way, then it's very hard for an individual who has worked for you under those conditions to have a claim. I would guess that those in the media are the exceptions to the rule. And obviously, if someone can claim a significant amount of money, that is headline worthy and headline grabbing. So maybe they are the exceptions to the rule. Obviously, if there's nothing written down, it was all a bit vague as to what was happening at the time, then there is a potential risk that can snowball. And as value develops in your brand and your IP, that's where the claims are made, which again goes back to the start of the conversation, is do protect your IP, do get it right up front. And then hopefully you're in the vast majority of cases where if there are claims, they're relatively spurious and you've got the documentation to back yourself up. But I would say the headlines are probably those exceptions where people haven't done those things up front.
Question 4. Fintech startup in St. Albans, Hertfordshire. Template request investment agreement. Okay, question she has is, we're entering our first funding round and needs an investment agreement template for first-time angels. Okay, so even the angel is first time. What clauses must we include to define investor rights, terms of equity issuance, voting powers, and liquidation preferences, whilst addressing the mechanisms for dispute resolution in case of conflicts between investors and founders? I'm guessing what she wants to ask is a contract that you would probably need to spend some time on and charge them a couple of £1,000, if not more. But nevertheless, let's hear it from yourselves.
Very interesting question. Keep it simple, because for this investment round, you will definitely need legal advice. But if you're looking for a quick template to understand how the clauses are put in an investment agreement, you can refer to, I think, the BVCA template, investment template would be a good example. So try and have a look at that. It also depends on how much equity you're getting, what kind of rights you want to negotiate. Are you getting voting rights? Sometimes investors invest without voting rights as well. So it depends on whether you want any reserve matter / veto rights. And the other point that I was trying to make, whether this will be SEIS compliant, because then in that case also you'll have to consider certain clauses that you can't have redeemable shares, etc. So yeah, from an SEIS perspective, also you will need to see it's compliant in terms of voting powers and all of that. Consider that. And for mechanisms of dispute resolution, you can have an arbitration or mediation clause, but again, we would need a set of facts for this to provide like a more detailed analysis of this. So definitely suggest you get legal advice on this before proceeding to invest, because there are a lot of considerations at hand. But yeah, your starting point could be the BVCA template. Thank you.
I'll try and keep it short because there's probably quite a bit you could cover on this. My immediate advice here is that given you're taking in angel investment, there's an advantage because they won't be institutional minded investors, they're professional investors. It should be possible to put in place a quite straightforward, plain vanilla set of investment documents, which would be the set of articles of association and a shareholders agreement. What I would suggest is you go as light as you possibly can, because the more involved it is, and if you start talking about things like liquidation preferences, that's actually going against you as founders of the business. So the name of the game at this stage would be as a founder group to maintain as much control as possible. So I'd be going with a single class of ordinary shares, forget anything like liquidation preferences. It would potentially, depending on the nature of the angels, you may or may not wish to give them some limited consent matters, but you may not even want to go there. And if you do, you might consider making sure that rather than it just being purely an investor decision, it may just be across the board, across the holders of the shares, and set the relevant percentage at the right level so as to limit or mitigate the chances of any kind of conflict or veto rights. And so I keep it as light as possible. You can have a look at BVCA, but if you do look at BVCA, those documents are already quite involved, and they really contemplate an institutional external investor coming in with a preferred class of shares. So I'd be going back for a significantly dialed back version of those documents. But yes, do get legal advice.
I think it depends on how the investment's happening. Is it SEIS? Is it actual shares, or is it a safe or something like that? And then, keep it simple, get advice. So actually you don't give away too much, because in a future funding round, if you get there, it may not be great if the angels have actually some of the rights that, a lead investor might want at the Series A stage or seed stage. So I think it's worth getting advice and getting it right and keeping it simple, like Andrew said.
Everyone's covered the legal part, and here's the thing that I am seeing. This answer that you've got about what to keep in mind looks like something an AI has provided you with. Taking a recording of this call and feeding it to an AI would be a very bad idea. I would advise that you do need a human being to help you with this. And as you are getting investment, you will be able to put some money aside to get proper advice. You do need to make sure you trust the people you're working with. I agree. Everyone worries about legal costs, and legal costs are a factor. However, they are a factor that every business needs to keep in mind. So my best advice would be, please don't AI this agreement. This would not be a good idea.
Thank you very much, Steve. I know you can't give us an exact figure, but for something like this, can you give us a rough guesstimate? What time frame and legal costs are we talking about that this person needs to bear in mind by going to a legal expert on this? If you can, would really appreciate.
The fact is, these things get negotiated. So let's say the first draft could cost you between 1.5 and 2.5 grand. That would just be a first draft. Now, if we draft it in a very collaborative way, if we draft it in a balanced way, it might go through. If it is very biased towards you, then negotiations will take much longer. So that will push your costs up.
Yeah, sometimes smaller law firms or smaller legal companies that operate as consultancies charge lower. So you could see somewhere in the range of £800 to £1,500 for drafting, plus additional, say, 2K for negotiations, depending on the rounds of negotiations. Somewhere, ballpark figure would be £3,500 for the whole transaction.
Glad I didn't go first to avoid being out of kilter. But no, I think it does really depend. One, you might not think it, but depending on how much you're looking to raise, people care a lot more about stuff or think about things a bit more. I think for something like this, if you've got some angels and it's not institutional money, and they're not terribly experienced, I would hope that you can lead this process. And it's not unusual for you as a founder group at this early stage to maintain significant control. And I wouldn't expect angels to really have any substantive rights beyond actually putting the money on, quite frankly. So I think you'd need to work on that assumption. I really think you should work on that assumption in the context of constructing that round. So with that in mind, I think you'd want to limit the negotiation. I think that ballpark around the 3.5, 4.5, up to 5K budget is sensible. The value add you're going to get from whoever you work with on this is not on the template. It's about getting some proper advice and guidance and making sure you put in sensible terms. So I would personally allow a budget up to, say, 5K would be sort of sensible, assuming we're talking about a relatively small funding round. And the benefit of that is not just for the funding round, but that you've got a nice, solid base, sensible set of terms to go forward as and when you look to do bigger and better things.
Expect something between 3 to 5K to end get it done is probably about right.
We'll start with the ladies. What are your parting words?
Well, thank you very much, Anton, and for everyone for listening. It's fantastic that you all are trying to educate yourself and using AI sometimes as guide. In my experience, sometimes it goes wrong. So maybe a standard search would stand you in better stead. I'm finding more and more using the sources directly get me to the point quicker and give me less irrelevance. As far as getting proper advice and guidance, I know you don't like to do it and you find it worrying as for the cost. With every area, I think we sometimes need your guidance, you need our guidance, and we need to all properly hire each other and get the right advice for the right pieces of work so that we end up with solid businesses.
I'd say that this year is very much about legal changes. There are a lot of changes slated to be introduced this year, whether it's consumer laws, GDPR, etc. So it's really important that you stay up to speed with the developments in law. I know it's boring, but make sure that your documents, contracts, and processes are all aligned with the changes, and be proactive this year about compliance to manage and safeguard your business risks. Thank you so much, everyone, for listening, and keep going.
Well, thanks everyone for listening. Appreciate your time. Just one thing to keep in mind, as and when you may be looking for external investment, just think very carefully about who you select as your investors on your cap table as well, because sometimes startups, particularly early on when they're desperate to raise capital and get going and building, they think it's more about the investor selecting them. And of course, there is a significant element of that, but it is a two-way street. So really important to think just a little bit beyond just the capital that's being provided. Do you want angels? Do you want institutionals? Do you want an angel which has strategic value that they may bring along? If you want a strategic corporate, do you want that, and do you need to think about some sensitivities or strings that attach to a strategic's money versus institutional VCs? So think carefully, do some reference checks, ask them at the appropriate time to be able to speak to fellow portfolio companies that they've invested in, not just the star ones, but also the ones that may have gone through some challenging time.
Getting the big stuff right early, long-term founder relationships, owning your brand and your IP, knowing what will happen if something goes wrong, with either investors or with co-founders, they're all the things that you should think about strongly early on and plan for and contractualize, because you look back and you'll have answers to the questions that come up 2 or 3 years later if you've documented it at the time. Other things are less important, but it's always the right thing to do to get things on paper. So get contracts down with suppliers, with customers, and things like that. And actually looking professional and being professional with legal documents is something that will make your business and your proposition more appealing to customers, because you look professional, you look maybe more advanced than you are as a startup. So getting these things right early is key, but don't sweat the legals so much that it paralyzes growth, because that's the opposite of what you need to do as a founder.
Thank you very much to all four of you. Really appreciate your time and absolute gold nuggets that you've dropped in for us today. Just before my parting words, a couple of quick things. Number one, we run 6 regular sessions helping founders rather, hopefully go from startup to scale up. Monday's talent, Tuesday's product and tech, Wednesday's growth, Thursday's fundraising. Second Friday of each month, as you see today, it's UK startup law, and third Friday of each month, it's UK startup finances. They're all from 12 to 1 p.m. UK time. They're all available on our website, startuptoscaleup.club. Again, it's startuptoscaleup.club. You can go there and pick and choose which one you want to attend and register. For those of you on the live streams, whether you're on LinkedIn, YouTube, Facebook, or Instagram, we are unable to monitor questions live. So next time, if you want to ask our panelists, you'll have to join us live on Microsoft Teams. Being audio only means that you can then join from anywhere via any platform or device. We got some amazing groups, a community of on WhatsApp of founders, investors, operators, legal and financial experts that you can connect with and discuss whatever's bothering you right now. And I guess all I can do is wish you an amazing weekend. Hopefully you'll join us on Monday for Startup Talent Q&A. Now, as far as my parting words are concerned, just remember the startup journey can be both exciting, also quite challenging. So try to have some fun in the meantime and be kind to yourself as well as everyone else for that matter too. Otherwise, again, thank you for joining us and God bless you all.